All right, we can start. So good morning, everyone. I, Dr. Anshu Mam, along with my colleagues, Ms. Manju Pundu and Ms. Kanchan Khatreja from School of Education, KR Mangalam University, would like to welcome you all for this 1 week online interdisciplinary faculty development program on meaningful research and intellectual property rights. It is being held in collaboration with the Faculty of Education, CCS University, Meerut. To give a brief about the School of Education at KR Mangalam University. So we aspire to become an internationally recognized department through excellence in the interdisciplinary arena of education, research, and innovation. We aspire to prepare socially responsible lifelong learners which can contribute to the nation building. Since 2016, the School of Education is striving to foster and maintain a creative environment with a deep commitment to inculcate excellence in academic and contribute towards students' development. The school brings an attitudinal change in the prospective teachers for their advancement into accountable agents of change in the society who are sensitive to the local, national, global concerns and issues vital for the human survival, progress, and development. So we offer B.Ed, DLEd, MA Education and PhD programs at our university. Before going ahead, at this point, I would request Professor Tanya Gupta, Dean School of Education at KR Mangalam University, to formally welcome all the delegates and the participants present here. Ma'am.
Thank you, Dr. Anshu. Good morning, everyone. On behalf of School of Education, KR Mangalam University, Gurugram, Haryana, I welcome the registered participants for this 1 week interdisciplinary faculty development program on meaningful research and intellectual property rights, which is being organized in collaboration with Faculty of Education, CCS University, Meerut, from 8th August to 14th August 2022. At the outset, I'm happy and I take the honor to welcome Professor Jaiswal sir, who is the Dean at the Faculty of Education, CCS University, Meerut. Welcome, sir. And it is really our pleasure that today we have started a journey of collaboration and miles to go together in academic and research work. I'll also like to welcome Dr. Manjeera. She's the resource person for today. The FDP is starting today with your session. Of course, once your technical session will be there, Dr. Manjeera, we will be formally introducing you, but grateful that you have joined the inaugural session. Welcome. Thank you so much. About this program that we are organizing, dear friends, dear colleagues, we know how important today and how emerging is IPR as an area in research and how much scope it has today in the present times. So this FDP is being organized basically to give an overview to the participants, to the faculty, to the scholars, to really understand how IPR is a major step to bridge the gap between innovation. How do you file the IPR? How is a copyright different from a patent, and so and so forth? And what are the IP violations, and what are the mechanisms that are in place, which will curb such violations? So basically, through this FDP, we are going to be on a week-long journey to understand various issues of meaningful research and IPR, like the basics of IPR. What is the systematic approach for writing research articles? How do we go about indexing and citations? How does one file patents? What is the documentation procedure? And what is a trademark? How is a copyright different from a trademark? What are the violations? And we will also be highlighting on plagiarism. So the whole objective of this FDP is to bring about awareness about the IPR, to encourage each one of you, in fact, each one of us as researchers, to to innovate, to bring in more patents, more trademarks, copyrights, because this is the need of the hour. And how do you actually do it in your research, inventions, and innovative projects? And also, this FDP endeavors to enhance the abilities of the faculty and the research scholars to conduct meaningful research. So we hope that after this FDP is over on the 14th, we will all be in a better understanding after hearing the views of our experts who are going to be there daily with us. We will understand the nuances of the IPR and meaningful research and learn the do's and don'ts of research. So with this, I welcome you all on behalf of our Honorable Vice Chancellor, Professor Dr. C.S. Dubeji, and our Pro Vice Chancellor, Madam, Professor Dr. Pushpalata Tripathi. I'd like to welcome you on their behalf. And I also look forward to have this sharing of the welcome address with our collaborating partner, that is CCS University Merit, for which we will be very happy to hear the views of Professor Vijay Jaiswal, sir. So all the very best for this FDP, and we will look forward that all the participants are there in all the sessions to gain the best out of this this program. So once again, I welcome each one of you. Wish you all the very best.
Thank you so much, ma'am, for kick-starting this session. Now I would request Professor Vijay Jaiswal, Head and Dean, Faculty of Education, CCS University Merit. A brief about him: with a more than 18 years of teaching and guiding dissertations at MEd and MPhil level and supervising PhD, he has worked as Associate Professor in Department of Education, CCS University Merit, and an Assistant Professor in Education Department, CSJM University, Kanpur. With more than 71 publications in various reputed national and international journals, and also chapters in books, and 2 major projects funded by UGC and ICSSR, he has got a wide experience in the field of education. So we request you to please enlighten our participants with the theme of this FDP.
Thank you, Dr. Anshu. I am audible?
Yes, sir.
Okay. Thank you, Professor C.S. Dubeji, patron of K.R. Mangalam University, Sona, Gurugram, and our Vice Chancellor, Professor Sangeeta Suklaji, though they are not present, but they are patron, and I think I must remember first all of them. And co-patron Professor Dr. Pushpalata Tripathi ji, conveners of this one big FDP, Professor Dr. Tanya Gupta ji, myself, Professor Vijay Jaiswal, Dr. P.C. Jaina, Coordinator, School of Education, and one of my bosom friend. Co-coordinators, Dr. Anshu Saluja ji, Miss Manju Kundu ji, Miss Kanchan Khatira ji, and all the other team members who are making untired effort from last so many days to make this program successful. As we know, research is an original and systematic investigation undertaken to increase existing knowledge and understanding of the unknown to establish facts and principles. Some people consider research as a voyage of discovery of new knowledge. It comprises the creation of ideas and the generation of new knowledge that leads to new and improved insight and development of new material, devices, and products. But the theme of this seminar is meaningful research. I think what is the meaningful research? Good reflective research produces theories and hypotheses and benefits any intellectual attempt to analyze facts and phenomena. Chief characteristics of any research should be attempt to solve a research problem, involve gathering new data from primary to first-hand sources, using existing data for a new purpose, is based upon observable experiences or empirical evidences, demands accurate observation and description, implies carefully designed procedure and rigorous analysis, attempts to find an objective, unbiased solution to the problem, and takes great pains to validate the methods employed. Along with these features, also there are some other features of meaningful research. It must be empirical, systematic, controlled observation, implies hypothesis, must be analytical, objective, unbiased, and logical, implies quantitative as well as qualitative techniques. One of the most important aspect regarding meaningful research is also researcher motivation. Researcher motivation, it matter to a great extent. A person may be motivated to undertake research activities because he might have genuine interest and curiosity in the existing body of knowledge, understanding of the problem. He is looking for answers to questions which remain unanswered so far and trying to unfold the truth. The existing tools and techniques accessible to him and others may need modification and change to suit the current needs. Some desirable qualities of research which also leads to meaningful research: purpose clearly defined, detailed research practices, research design, rigorous research design, must consider ethical issues, must consider limitations and limitations, results and findings, conclusion, recommendation, and researcher experience. Along with these features, there are also some precautions in research also. Whether a researcher is doing applied or basic research or research of any other part, he or she must take necessary precaution to ensure that the research he or she is doing is relevant, timely, efficient, accurate, and ethical. The research is considered relevant if it anticipates the kinds of information that will be required by decision makers, scientists, or policy makers. Timely research is completed in time to influence decision. Research is efficient when it is of best quality for the minimum expenditure and the study is appropriate to the research context. Research is considered accurate or valid when the interpretations can account for both consistencies and inconsistencies in the data. Research is ethical when it can promote trust, exercise care, ensure standards, and protect the rights of participants in the research practice. So these are some characteristics of meaningful research, and this must be highlighted during the research practice. Along with this FDP is also very focus on very thrust areas like basics of IPR, intellectual property rights, systematic approach for writing research activities, indexing and citation, which is also much more important in the context of research, meaningful research, filing of patent and documentation procedures, industrial design and geographical indication, fundamentals of trademark, copyright violation and related rights, plagiarism prevention. So these topics are very much relevant in today's research. It is need of the hour to discuss these topics because many researchers and also researchers and supervisors both do not have very much clear understanding of these topics like IPR, plagiarism, how to avoid plagiarism, how to deal with copyright problems, copyright issues, fundamentals of trademark, how to file patent. So I think this FDP will be proved very much meaningful, and all the experts' view and academic discussions and deliberations will broaden mental origin of our participants. Thank you very much. Thank you.
Thank you so much, sir, for your kind words. And I would like to thank Professor Tanya Mam and Professor Vijay sir for throwing some light on the central themes of this FDP and inducting the participants on research and IPR. So moving ahead, since we have Professor Manjeera Sakia with us, and I would like to welcome you, ma'am. And a brief introduction about about her, as she's an assistant professor at School of Law, University of Science and Technology, Meghalaya. She pursued her LLM from Lovely Professional University and BA LLB from BRM Government Law College. Her areas of interest is intellectual property law, environmental law, criminal law, and cyber law. She has published a number of research papers in journals of international and national repute. She had also participated in various national and international seminars and also participated as a resource person in a few. She has also participated in various faculty development programs for the enrichment of pedagogical and teaching skills, and has been an active member of various legal aid camps conducted for the needy. With her grooming and time management skills, she has been training the students in their areas of moot court and personality development. And prior to joining University of Science Technology, her work experience include judicial clerkship under Guwahati High Court, resource person in state training workshops by Consumer Legal Protection Forum Assam, and beside teaching, she is trained Satriya dancer and completed her BA in the same, and has been trained in various other dance forms such as contemporary, etc. So, ma'am, we welcome you all on this platform, and we look forward for quite an enriching learning experience from you.
Thank you, Dr. Anshu Mam, for beautifully giving the introduction. So, may I start?
Yes, ma'am.
Okay. So, a very good morning to all. Honorable Vice Chancellor K.R. Mangalam University, Professor C.S. Dubey sir. Honorable Vice Chancellor CCS University, Meerut, Professor Sangeeta Shukla Ma'am. Honorable Pro Vice Chancellor K.R. Mangalam University, Professor Pushpita Tripathi Ma'am. Respected Dean, School of Education, K.R.M. Mangalam University, Dr. Tanya Gupta Ma'am, whom I have been in touch with. Respected Dean, Faculty of Education, CCS University, Professor Vijay Jashwal sir. Thank you, sir and ma'am, for inviting me to this FDP program. And I'm really, it is a great opportunity and pleasure to interact with all the faculty members and the research scholars who have joined here today. So I'll move on with my topic, that is intellectual property rights. So with your due permission, may I start the screen sharing?
Please go ahead, ma'am. Please go ahead.
Please let me know if I am audible and visible in my slides. Ma'am, is it visible?
Yes, Dr. You can start. Yeah, visible.
Yeah. So as we know, IPR is a very fast-growing subject, and as the competition has grown, the importance of IPR has grown many folds. Like the NEP 2020 have mentioned about the IPR subject and have spoken about the skill development, the development of innovation, the development of invention. Also, the UGC, that is the University Grant Commission, have also mentioned about the subject of including it in the as an elective subject for the choice-based credit system. IPR is a very important subject, and it has been even included in the schools for an early innovation among the students. And there are many schemes like the IPR scheme, Kiran IPR scheme, which helps women train in the field of science and technology. So we get an idea how important IPR is in today's time. So without any further delay, we will directly start the topic. What is the meaning of intellectual property rights? So you can see in this slide the intellectual property rights, the name itself indicates what it includes, like the property, the word property. So intellectual property rights has its root in the property laws. So property can be divided into two categories, tangible and intangible properties. So tangible properties are those property which we can see, touch, or feel, where intangible properties are the properties like the intellectual property rights, the patent, the copyright, the trademark, which we cannot see, touch. So the intangible properties are the intellectual properties, and the tangible properties are the land, the chattels. So intellectual property rights is the right over the intellectual property which is intangible. So the Constitution of India under Article 300A have mentioned about the intellectual property rights, saying that intellectual property rights is included in the word property, which is also given for the tangible property. Also, there is also mentioned in the Constitution entry 49, list 1 of the Constitution, which speaks about the power of the Parliament to make laws regarding the intellectual property rights. So there are various laws and legislation which protects the intellectual properties such as the copyright, the trademark, the design, the patent. So all these are categories of copyright, all these are categories of the intellectual property rights which can be protected. So there are various categories of intellectual property rights. So it is the patent, the trademark, the copyright, geographical indication, industrial design, and trade secrets. So here, the patent signifies inventions or innovations. So it protects all kinds of inventions or innovations which are new. So we will discuss one by one what is patent, what is trademark, copyright, geographical indication, industrial design. So trademark includes the logos, the symbols, the name or the device mark. The copyright includes the musical work, the literary work, the artistic work. Geographical indication includes the manufactured goods, the natural goods, the agricultural goods. Industrial design promotes and protects the aesthetic in an article. Trade secrets protect the rights of confidential information. So these are the categories of intellectual property rights which are protected by various legislation, which are kind of different for each category. So we will be moving on to what is the need of intellectual property. So as Vijay sir has already given you an idea of what is the need of intellectual property. So since you all are from the educational background, so the need of copyright is very essential. The awareness of copyright is very essential for you all. But we need to have an awareness of as a whole the patent, the design, the trademark. So strong IP helps to make an educated choice about the safety and reliability and effectiveness of their purchase. So it helps the consumer to distinguish the quality goods from the defective goods or the goods which are kind of duplicate. Enforce IP rights and ensures products are authentic and of the high quality that consumer recognize and accept. IP fosters the confidence and ease of mind of the consumers. So here it promotes firstly the science and technology. It promotes the science and technology and also kind of encourages the inventions, the innovations, the creators to create more works on their subjects and gives rewards for their creativity, give rewards for their inventions. So it is very important in all the fields, not only in the field of law, but in all the fields, IPR is important. So like the McDonald's and the Burger King earlier had franchise only in US, but now it is available in worldwide. Like in India also it is available. But the only challenge that IPR has is that IPR is kind of national or regional. So the rights that we have in one particular area may be different in other areas, or that particular right may not be present in such areas. So that is the only challenge that IPR has. So it also increases the level of productivity and competition in the export market and can accelerate the intellectual property. So IPR kind of, for example, GI, geographical indication, which helps the small scale industry to grow, or IPR plays a very important role in the economic development of the country as it helps the small scale industries or helps the people in the remote areas to represent their work internationally or globally and earn profits from their work. As John Locke had mentioned in his theory that everyone should have the fruit of his own labor. So one who creates the work should be benefited from that work. So keeping that in view, the intellectual property rights try to protect all kinds of intellectual property and give the right owner of the property the reward for their work. So there is a fixed term for each of the intellectual property. Like for patent, it is the 20 years. 20 years term of protection is given to patent. GI and trademark is an exception, which is which can be renewed year after year. Copyright is given for lifetime plus 60 years, and design is given for 10 years plus a renewal period of 5 years. So here, if we give an example of the books of Mahatma Gandhi, the father of our nation, the 3 books of Mahatma Gandhi, which are like my experiments with the truth, the history of revolution in South Africa, and the Hind Swaraj. These 3 books were copyrighted from the year 1948. As the term is given, copyright is for lifetime plus 60 years. So after the death of Gandhiji, these books were protected under the Copyright Act of 1957. And it was under the ownership of the Navajivan Trust, which was the heir of Gandhiji. So these books were protected, and after this time period expired, so these books went to the public domain. So now the people can use the book, can reprint the book, so they can have they can use it for their personal purpose also. So what happens is that after the time period expires, the public gets the right to use it, to reuse it without the consent of the owner. So these rights are exclusive right given to the owner of a property for a particular time period. So we need to remember the time period for which it is given. For patent, it is 20 years. For GI, it is kind of perpetuity, which can be given forever, which can be renewed forever, which is not fixed. So similar way, copyright and designs are also given limited period. So we cannot say that we have exclusive right forever, because we need to keep the work flow along with keeping the rights of the creators alive. We need to protect the rights of the creators on one hand, and also we need to keep the flow of the work going on. So it serves both the purpose. So this is the time period which is given for intellectual properties. So the current IPR laws in India are the Copyright Act of 1957, the Intellectual Property Rights Enforcement Rule 2007, the Design Act 2000, the Design Amendment Rules 2008, Geographical Indication of Goods Act 1999, the Geographical Indication of Goods Rules 2002, Information Technology, the Information Technology Act 2000, the Cyber Regulation Appellate Tribunal Procedure Rules 2000, the Patent Act 1970, the Patents Amendment Act 2005, the Patent Amendment Rule 2006, the Trademark Act 1999, and the Trademark Rules 2002. So since the tangible properties like the land, the chattels, the laptop, the mobile phones, since those material things are protected by various laws like the property law, like the Sales of Goods Act, and various other laws are there. The Consumer Protection Act is there to protect all the material things or the material property. So in order to protect the intangible property or the creation of human brain, so the intangible property should also be protected. So for this, all the acts have been given under Indian legislation. This act has been made to protect various type of intellectual property and promote the creators and inventors to work more in their fields, to encourage them to work more on their fields. So starting with the first category, that is the patent. So patent, when all the people were kind of shaken, the whole India, the whole world actually was shaken by the COVID-19 pandemic. So there were a group of researchers from the IIT Bombay who have made various type of face shield, which had the hydrophobic layer resulting in the resulting from the protection of the airborne infections. So they have prepared this during the COVID-19 period. So these inventions need encouragement. So the Patent Act have protected such type of invention and given credit to the inventors, by which they get encouragement to make more and more inventions like this in future. So in the similar way, the cytec arian is a negative iron generator which produces the viruses, bacteria, fungal infections, spreading COVID-19 positive cases. So this was proved to reduce 99.7% viruses and scientifically tested to reduce the viral load by 99.7% in a room. So such generator is helpful to treat diseases like influenza, allergens, bacteria, and fungi. So these are the inventions which help the people in the time of COVID pandemic. So such type of inventions need protection, which the Patent Act provides. Another invention was the web care and automated secretion management and closed system of oral hygiene, which helps the ICU patient with mechanical ventilation by accurate removal of saliva and secretion, protecting the healthcare personnel who has a risk of exposure. So it helped the ICU patient and also the workers in the hospitals to protect themselves from the virus or the infections which were prevalent at that time. So these inventions were protected under the Patent Act, which was provided by the Indian Patent Act. So what is patent? So in order to understand this kind of inventions, can all inventions be patented or can all inventions be protected? We need to first understand what really patent is. So patent is an exclusive right granted to any person who has invented new and useful article or improve of an existing article or a new process of making an article. So here by article means the things or the inventions which are made. So anything new or improved on an existing article or a process. Earlier, it was only the process patent which was given before 2005. So after the year 2005, the product patent were also given protection, like on the substance itself. So it is an exclusive right that an inventor or innovator has against his inventions or innovations. When a person have that patent, he gets the right to use it exclusively, and he can sue others. He can file a case against others, or he can defend himself from others who are using his inventions without his consent, or who are using using the same kind of patent. So he gets a defense if he gets registered under the Patent Act. So patent also includes for a limited period, which we all have already mentioned that it is for 20 years. So the basic criteria for invention can be of three types. The first is the new or novelty. So by the word new or novelty, it means the patent should not be published in any publications or into the public. The invention should not go into the public or should not be disclosed in public. So we all know that the human mind is like a bird. Given the wings, it will fly beyond imagination and bring new inventions. But those inventions need to be protected. So these new inventions need to be protected. So if an invention is made, we cannot go and directly share it to the public. So it must be protected first, and then we can share it with the world. So the invention must be new and novel, and it should not be disclosed in public before it is patented. So it is not necessary that there should be a patent registration. But if one does a patent registration, it will be helpful for him later to fight in the legal disputes. It will help, it will serve as an evidence in the legal disputes if any such case arises. So it becomes a risk if there is a new or novel patent and a person is keeping it with himself. So it increases the risk as no one is bound, no one is either bound or no one is kind of liable for such disclosure. So it may lead to many other consequences. So the patent should have the new and novelty thing to serve for the to become a subject for the protection under the Patent Act. So next is the inventive step or the non-obviousness. The inventive step here refers to a technical advancement. So merely changing a substance from polymeric material to a bamboo material will not serve the purpose of the patent. So inventive step means it should not be that obvious that a person of that field, particular field, kind of knows how that thing is made, how that particular invention is made. So it should be kept in mind that there should be a technical advancement of such things, technical, or we can say there should be some kind of creativity in that particular thing, which a person who is expertise in that field does not know. The next is the industrial application. Industrial application or the utility. Here utility means it should be capable of industrial application, or the invention that has been made should be capable of being made in an industry or should be capable of using in an industry. Only then it can be patented. So we need to remember these three criteria which are very much needed for the patent protection. So if these three things are not fulfilled, so patent, it will be difficult to get patent protection. So new novelty, inventive step, and industrial application should be there for the patent protection. Now let us look into a case of novelty, that is Lallu Bhai Chakku Bhai Zariwala versus Chimmalal Chunnilal and Co. Kind of the name is interesting. The Bombay High Court here held that the real test for patent is novelty. So as we have discussed that the patent, in order to get protection, should be new or novel. So here in this case, the patent holder filed a suit against an alleged infringer stating that his process of treating dry fruits amount to patent infringement. So he has made a case saying that his process of treating dry fruit is similar to the other person's patent, other person's invention of treating the dry fruits. The court in this case compared the patented process and alleged infringer's process and held that there were no infringement because a substantial step in the patent process was not present in the alleged infringer's process. So here the court mentioned that substantial process or a substantial step must be copied, then only it will be considered as the patent infringement. So here the court has compared the two-person inventions, the patent holder inventions and the alleged infringer's inventions, and the court have compared both and have seen what things are copied. So the court has found out that the substantial step, that is the most important step for making that particular thing or distinguishing that particular thing from other invention, that was not copied. So the court held that that was not an infringement in this case. So as we have also discussed, what is the inventive step, like the technical advancement, merely changing the material of a thing does not lead to a patent or an invention. So here in the observation in Bush versus Fox, it is said that if one man invents a new method of looking into the moon, someone else cannot take out a new patent for looking at the sun. So this is the mere difference. Only from the land and from the sea, no person can make the same telescope. So there should be an inventive step, or there should be a creativity in making that thing different from one another. So section 3 and 4 of the Indian Patent Act here mentions about the things which are not inventions, which are not patentable. Like we may feel that when we talk about patent, all inventions are patentable, but we are wrong. There are many inventions which will not be patentable, which will be rejected as an invention. So they are given under section 3 and 4. It is very clearly given by the Indian Patent Act. There's whatever comes under section 3 and 4 of the Indian Patent Act will be rejected as patentable. So let us look one by one. The frivolous or the criminal act. So the frivolous invention which claim anything obvious contrary to the well-established law cannot be patented. For example, a machine it is saying that a machine to produce a perpetual motion, which cannot happen. So that type of invention can be an exception for patent protection. So the second is the criminal act, or the act which goes against the public morality. The invention which are made against the public morality, like the machine for pickpocketing or counterfeiting, for the counterfeiting currencies. If all these type of inventions are made which goes against the law or the public order, such type of inventions will be rejected from the patent protection. Or a mere discovery. Here, mere discovery means patents are given only for inventions and not for discoveries. So a mere discovery of a living or a non-living substance cannot come under the category of invention. So, but a discovery may sometimes become patentable if that discovery leads to some other conclusion which may lead to a process of new invention. That type of discovery may be patented. The next is mere admixture. So here mere admixture means mixing the two things not necessarily becomes an invention. To be an invention, there must be some formulas for creating that invention, some hard work for creating that invention. So by mixing milk and water kind of things cannot be inventions. So next is the plant and animal in whole or any part thereof other than microorganisms. So plants and animals are exempted from the protection of patent or inventions, but microorganisms are included. The plants, like the procedure for planting or the procedure for growing mushrooms. So all these are excluded from the patent protection. Other than that, the microorganisms are included for the patent protection. The methods of agriculture cannot be included in the patent protection, or the mathematical methods cannot be patented. Any process for the medicinal purpose, or the things like administering medicines orally or through injections, those things cannot be patented. The surgical things like the stitch-free or the stitch-free incision for cataract removals, the curative methods, the prophylactic methods like the methods of vaccination, diagnostic methods like the identification of various illness, all these type of things cannot be patented. The therapeutic or other treatments of human beings cannot be patented. So this comes under section 3 of the Indian Patent Act. The software patent. The next is section 3K which refers to the computer programs per se. This means that you cannot get a patent for the software program by itself in India. So by this, it means that we cannot get a patent directly for software. But if that software is attached with a novel hardware, it can get the protection under the patent. Otherwise, and the rest of the software things or the source code are protected under the copyright. So it is protected as another intellectual property. So software as a software under the patent can also be protected, but to do that, we have to attach it to a hardware. So section 4 talks about no patent shall be granted in respect of invention relating to atomic energy that fall within subsection 1 of section 20 of the Atomic Energy Act 1962. So it is upon the discretion of the central government to take the decision or to take the call for the atomic energy. So it is said that it will not be patented. So it is the call of the central government to decide if it will be patented or not. So next exception, which is given under 3 subsection P, is that an invention which is in fact the traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components. So traditional knowledge, which is the knowledge that passed from one generation to another generation, orally, which is done orally from one generation to another, can be said to be the traditional knowledge. So India, being a diverse country, has various knowledges which we follow, which are being followed from various generations and have been passed to us. Like in the COVID-19 pandemic, when there were no vaccines, so India kind of made a drink with all the herbal things which we call kara, and which helped the immunity, which acted as immunity booster. So those are the traditional knowledge which we have and which needs to be protected. There is a thing called traditional knowledge digital library under which these things are protected, and it also can be protected under the Patent Act. So the Patent Act looks into this type of aspects which we can protect. So since we do not know what is traditional knowledge, so many of our things are being stolen already. And so we need to have the awareness of IPR, that what are our traditional knowledge and what things can we protect under the traditional knowledge system. So traditional knowledge includes the cultural things, the medicinal things, the agricultural things, the folklore, be it dance, music, or the stories that our grandmother used to say. So all these type of things which has its root in the past. So those knowledge that we have got from our great grandfathers. So those type of knowledges should be protected under the Patent Act. So here is the definition of traditional knowledge. So handicrafts will come under traditional knowledge, the medicinal, agricultural, ecological knowledge, the music, dance, stories, poetries, the spiritual expressions, the collective responsibility, ownership, transmitted orally across the generations. So we need to protect our own traditional knowledge, as we have many, like the turmeric case, the famous turmeric case. There is also the basmati rice case. There is also the jamun case. So there are various landmark cases which India has fought against many other countries for our own things. Like in the turmeric case, a US patent on the turmeric was awarded to the University of Mississippi Medical Center in 1995, specifically for the use of turmeric in wound healing. This patent also granted them the exclusive right to sell and distribute the turmeric. A complaint was filed in India's Council of Scientific and Industrial Research, which challenged the novelty of the university's discovery and has finally won the turmeric for the India. So there are the basmati rice, which the US also got patent in some other name, but the basmati rice finally got the GI tag in the state of Delhi and Haryana. So these are the kind of cases where we need to protect our own things from other countries, because the developing countries or the less developed countries which are kind of lagging behind in IPR. Therefore, the awareness of IPR to know the rights that are provided under IPR has become very important in today's generation, as many things are being already stolen and we need to protect our own things. So there are many GIs or geographical indications that are being taken, since the laws are different in different countries. So we need to protect our own things by our own laws, so that the things that we have seen from our childhood does not go away. So the next is the copyright. So I guess you can see the image. The copyright, this is the famous monkey selfie case. It was a US case. So it was a selfie taken by this monkey. So there has been a series of dispute from kind of 2011 to 2018 for the status of this photo. This photo was actually taken by this monkey, and the camera was of a person called David, who was a wildlife photographer. So he went to the jungles and the monkey snatched his camera and he took a selfie. Now the question that comes here is, who holds the copyright, or who is the owner of this photo? So whenever we click a selfie in our mobile phone, we become the owner of our copyright. But in this case, who holds the copyright for this photo? So the owner, that is the David, who was the photographer here, he has used the photo and he has published in a magazine. So later on, there was a case against him by the People for Ethical Treatment of Animals, that we call PETA. In 2015, the PETA has filed a case against the photographer, saying that the photographer has violated the right of the monkey, as the monkey holds the copyright for this photo. So the case went from one court to another. The court had the question whether the monkey, whose name was Naruto, had any relationship with PETA. Why is PETA filing a case who has no relation with the monkey against the person called David? So in order to file a case in law, since you all are not from the law background, I would like to mention, when there is a case, there needs to be a plaintiff and a defendant in a civil suit. So if a person is incapable of filing a suit, then, or who is a minor, then a guardian comes, or who is called a next friend. A guardian or a next friend comes on behalf of him to file a case. So here, the question that was put by the court was, that is the organization, that is the PETA organization. So are they the next friend of the monkey, or how the monkey and the PETA are related, that they have filed a case against the photographer. So this case was kind of concluded in a confusion, and it ended that they do not have any significant connection, and therefore they cannot file a case against David. But later on, the case was settled outside the court, and David had to give some percentage of his revenues to the organization for using the photos in that magazine, or for any future interviews. He had agreed to pay some percent of the revenues to the organization. So this type of landmark cases makes us learn what is the copyright, or the copyright in photos, copyright in literary work. Since you all are from the educational background, so copyright is a very important thing in the field of research when you write be it the poem, be it the novels. So it is a very important to know how to protect your research work, how to protect your books, the novels, the stories, so your writings as a whole. So let us study what is copyright. So copyright law is divided into few classes, which we call as the works: the literary works, the paintings, the photographs, the drawings, the films, musics, choreography, the sculptures. So all these are the works that are protected under the copyright law. So they are divided into sections, and they are protected separately. So under the Copyright Act 1957, copyright subsists in the original literary work, the dramatic work, musical work, the cinematograph work, and sound recordings. The UK Copyright Act of 1911 and 1956 also required the originality of the literary, dramatic, musical, and artistic work for subsistence of the copyright. According to Section 13, that means here Section 13 gives the definition of what is work and what kind of work will be protected. As we have seen in the earlier screen, and that copyright protects the original literary work, dramatic work, the musical work, all kinds of musics, the artistic works like the engravings or the etchings, the sculptures, cinematograph films, and sound recordings. So these are the works which are protected by the copyright. So original literary work. So here original literary work, original literary work, the word original here, we need to focus on that, as because literary works are protected only if it is original. However, there is no test of such originality, but it is simply said that copyright to be original needs to be the original version of the work and not a copied version of the other works. So there is not a test really, but it is said that substantial labor, skill, and judgment should be there in that work. Then it will be it will fulfill the category or the criteria for the protection of copyright. So copyright subsists in the original literary work. It is not necessary that the work should be expression of original or inventive thought, as the Copyright Act is not concerned with the originality of ideas, but with the expression of thought. So here I would like to mention that copyright is not in ideas, but it is in the expressed form, be it in writings or be it in printing, but it should come into some forms. So whenever, for example, if one of you is writing a poem and you have showed the poem to one of your friends, and your friend have actually published it the other day, so you will have no copyright protection over such things. If you just give an idea, if you just share the idea orally, but it should be in written form. If it is written form, the copyright protection generates automatically. As the Berne Convention mentions, that copyright is an automatic protection. It generates automatically once you convert it into a writing form or an express form. But there will be no copyright for the ideas. Ideas cannot be protected in copyright. But we can say that in plagiarism, if you copy the idea of one person and use it without giving credit to the owner of that work, that will lead to plagiarized work. So copyright and plagiarism has a difference. So copyright is kind of a set of rights to the owner who owns it. It is a set of rights to sell it, or to assign it to other person, or to transfer it to other person, or give it to other person for a particular period of time. But on the other hand, plagiarism is a protection given to the owner if the works are used by someone else without giving the credits. So it is unethical in that sense. Plagiarism is unethical, and the copyright is kind of the legal rules or the legal rights which are given to the copyright owner. So there is one thing called this doctrine of Swedenborg, which comes under the literary works, which was followed by India for a very long time. This is a doctrine which says that a person should earn the fruit of his own labor, or should be able to enjoy the fruit of his own labor, who invests his time, his energy, his skills. But this doctrine was changed a bit later on, and the flavor of minimum creativity was included in that doctrine for the original work. That means, to be an original literary work, it is not only sufficient that that person has invested his time and energy, but along with it, that person should have some creativity in that work. So by just drawing a circle, for example, by drawing just a circle or a line, the person cannot get a copyright for such drawings. So to be a copyright, that should have some creativity from that circle. That should be some other character, that should take other character. Then only it will be a copyrighted work. So we need to keep in mind, before creating a literary work, we should not copy. That should be our own thing. We should not copy from others. And secondly, if we copy, we need to take the permission. We need to give the proper credit to that person from whom we are taking the things. And we should have our own creativity in that particular work. We should put our own creation. Since copyright is given to encourage more and more creative works, to give more and more good literature, good artistic work. So here, the Copyright Act tries to encourage the creators of those work by crediting them. So while creating such work, we need to give credit to these persons from whom we have taken the things. So the right of the copy holders is mentioned under Section 14 of the Indian Copyright Act 1957, which gives the exclusive right of the authors of the work who can do or authorize someone to do all or a part of the activities under the section. So like the patent or the GI or the trademark, the copyright is a kind of set of rights. There are many rights which are under copyright. It can be the moral right of the authors. It can give a person assignment, it can transfer, it can be such type of property can be sold. So copyright is said to have sets of right, and that right can be given to another person depending upon the consent of the owner. So if you want to give your copyright to others, you need to give your consent, full consent or partial consent. So it depends upon you what you prefer. So there is also an important topic which we need to discuss when we discuss the literary work, that is the fair use doctrine. So fair use, that means it is an exception which is given to the copyright law. Exception in the sense that if we use the copyrighted work, that will not lead to infringement. So infringement here means violation of the law. So there are few things like the research work or the educational work, if we are using it for personal purpose, or if we are using it for the criticism or for the review purpose, or if we're using it in the news for the current news, or you are using it for putting photos in the newspaper. So all these are the exceptions where we can use a copyrighted work without taking the permission. And copyright law allows it under the fair use doctrine, where it is said that if you use a copyrighted work, that will not lead to any infringement. For example, now I am showing you the slides. So one of you can pick up my slides and use it in your YouTube videos, but that will lead to an infringement. So why? Because though it is for the educational purpose, though this lecture is for educational purpose, but if you are using it commercially to earn the benefits, so that will lead to be an infringement. So if you're using it personally for your personal purpose or for the research purpose, then it will not lead to an infringement. But if you are benefiting commercially, if you're selling it, if you are distributing it, and if you are earning benefits from it, then it will lead to infringement. So copyright law is kind of flexible. It at one hand protects the right of the owners, and also it is flexible by giving such doctrines, fair use doctrines, where you can use the work fairly with the consent of the owner or without the consent of the owner if it is for your personal use. So moving on to the next topic, that is copyright in ideas, the plots, themes, or the concept note. So as we have already mentioned, that copyright cannot subsist in the ideas. So can copyright subsist in concept note? So you all might know what is the concept note. A concept note is kind of an outline of a research work. So can those concept note be copyrighted? So in RJ Anand versus Deluxe Film AIR 1978, the Supreme Court held that there could be no copyright on idea, subject matter, themes, plot, historical or legendary facts, and violation of copyright in such cases was confined to the form, manner, and arrangement and expression of ideas by the author of the copyrighted work. So here, in this case, it was said that there will be no violation of copyright, but the violation will be considered depending upon its form. If it is expressed in a form, if the ideas are later expressed in a form, then only it will come under the preview of protection. So there was another case that is under the Delhi High Court, Anil Gupta versus Kunal Das Gupta, 2002. Here, the plaintiff and the defendant. So the plaintiff is the person who files a case, and the defendant is the one against whom the case is filed. So in Anil Gupta versus Kunal Gupta, 2002, the plaintiff had made a concept note, and he has given his idea that there should be a reality show, television reality show, which is kind of selection of groom by women, which he named as Swamber. So he has given this concept note to his friend who was the producer of the televisions. So he has shared this concept under confidential agreement, but later the defendant, the Kunal Das Gupta, he had made his own show, giving it another name, saying it is Shubh Vibah, giving it another name Shubh Vibah, but the concept which that show had was similar to that of the plaintiff. So therefore, the plaintiff filed a case in the court, Delhi High Court, saying that his copyright is violated. So here the court held that there is no copyright per se in ideas. So ideas cannot be copyrighted, but since he has made his idea clothed with some the whole concept of what he is going to make, there will be selection of groom by women. He has mentioned that particular idea or the system that his show will be upon. So the court held that it will be protected under the law of copyright. So when an idea is expressed or clothed with some detailed concept, when the detail is given, then that type of ideas can be protected. So in law, it is kind of a general rule and always an exception which is provided. So copyright in ideas is not protected, but if it is clothed with the concepts or the detailed outline of that particular idea, then it can be protected. Now let us move on to original music work. So under section 2B, the definition of musical work is given, and it means the graphical notation of such work, but does not include any words or any action intended to be sung, spoken, or performed with music. So it includes the graphical notation, but not anything intended or anything that a person has in his mind. So it indirectly says that it should be a graphical notation of such music. It should not be in the human brain, or if someone is thinking to play a particular song, so that cannot be protected, but it should come into a material form. Only then the musical work can be protected. So let us kind of look into some Bollywood music. So I'm sure you must have seen this movie, the Badshaho movie. So it was released in September 2017, and it was kind of taken from the 1975 hit movie Diwar, which I'm sure everyone must have watched. So this song was taken from the movie Diwar. The song is the Keh Do Tumhe, and the producer of the movie had remixed the song without the permission of the copyright song owner. So here the copyright owner was neglected, as his song, the person who has made a remix of his song did not take the consent, so which will lead to copyright infringement. So copyright infringement means the copyright violation. So there can be various punishments for copyright violations as well. It can be civil punishments, or it can be criminal punishment or administrative punishments. So there are 3 categories of punishment which can be given for copyright violations. So in civil remedies, it can be injunctions, it can be compensation. In criminal, it can be fines, it can be imprisonments. So we need to be very careful when we are using other person's work. So in this Bollywood song, the permission was not taken, so it led to an infringement which had its own consequences. Again, the song, the Tamma Tamma, which you might be aware of, there has been a remix of the song Tamma Tamma, which was also in the dispute, in which came to the court for not giving credit to the original owner. So the similar case was held in the Amir Khan show Satyameva Jayate, the theme song of the Satyameva Jayate, which was found similar to the Palasin song, which was also named as Satyameva Jayate. So these are the things which were, as a Indian citizen, we need to remember. So whenever we are copying any song, whenever we are listening to any song, are we really giving credit to the owner? We need to check if we are giving the credit to the right owner or not. So this kind of infringement has necessitated the amendment of copyright laws, which was amended various times. Till now, it has been more than 5 times that the Copyright Act has been amended. In the year of 2002, that was the latest amendment that was done in the Copyright Act. And there should be more amendments because such type of infringement are growing in India. So next, and that is the graphic characters. The code in the detective comic book, the superhuman powers, is not capable of protection. The Copyright Act says that the superhuman characters or the graphic characters are not subject of copyright protection. Like here we can see the image of the James Bond, image of the Chulbul Pandey from the movie Dabang, or the superhuman, the Superman, the Wonder Woman. So all these characters cannot be copyrighted, which was said by the copyright law. But it also have given an idea that if that superhuman power have been clothed with what will be the emotional characteristics or what will be their powers, if that is defined, then that kind of characters can be protected. Here, the case was that the Wonder Woman had the same physical and emotional characteristics of the plaintiff well-known character Superman. That means the Wonder Woman had been copied from the Superman character, and the characteristics, the emotional, the physical characteristics were the same. So the court held that that is the violation of copyright law. This thing, single-handedly, the graphical characters will not be protected, but if the graphical character holds that significance of how they act, how their emotional things are, how their physical things are, how their clothes are. So if all these things are attached with the graphic characters, then the graphic characters can also come under the purview of copyright protection. So next is the painting. So painting is the art of representing or depicting by colors on surface any artistic work. The painting is protected as an artistic work, whether or not it possesses any artistic quality. So like the music, like the literary work, like the sculptures, or like the engravings. So painting is also protected under Copyright Act. So with the painting, also the moral right are also attached, like the right given by the copyright, as well as the moral right, which are also attached to the copyright. So there was a case where the painting of a person was kept in a place where the owner of that painting got affected because he had emotional attachment with that painting which he had made for years. So we need to keep in mind that the right owner gets the credit for the painting, and also his moral right is not violated. Such type of moral right is also violated sometimes while doing the remix of a song. Like nowadays, various kinds of songs are being remixed. So in the similar way, the moral rights are attached to such authors or such creators of such music. So we need to keep in mind that the owner or the maker of such music or the paintings are not affected by the use of such things, by copy of such things. Even if we take the permission of such copyright owner, we need to keep in mind that his moral rights are not violated. If I keep a painting which has a great significance to the owner in the kitchen or in front of the toilets, so that will lead to be affecting the owner very deep, which he might have spent years on that paintings to create that beautiful painting. So we need to kind of respect those type of rights also, because the author of the painting need to show the employment of either skill in painting or work and labor in seeking to depict some actual or abstract design. The work cannot be protected. So it is also said that in order to come under the preview of the copyright protection, the painter also need to show that he has spent labor in that painting, or he has used amount of skill in that painting. So he has to prove that in order to get the copyright protection. So let us move on to the next topic, that is the trademark. So with the emergence of the kind of competitive market, economy, so the manufacturers have kind of used the symbols, or have tried to identify their products by giving it a particular sign or symbol, or kind of a mark to distinguish their products from the other competitors. So the trademark has become very important in today's world. So we all know that from the dawn to dusk, we have come in contact with lots of trademark, starting from the time we get up, that is the toothpaste that we use, the tea that we drink. So all that have the trademarks. So we unknowingly have we do come across hundreds of trademarks in a day, like while booking a cab, Ola, Uber that we use. All those are the trademarks or the brand names which we see every day. So here are few which we all know: the Godrej, the Dabur, the LIC. So all these are the trademarks which distinguishes the product from one brand to the other brand. So the aim of the trademark law is to protect the manufacturers by helping them to distinguish their product from one another, and also it kind of protects the trademark owner, the trade and businesses. So once they are protected, the duplication becomes a violation of the trademark law. So therefore it is very essential that, since the market is growing, it is very essential for the business owner or the market to protect their products, protect their logos, to protect their symbols, so that their reputation or the goodwill stays, or it stays alive. So it is very essential that we know about what is copyright, what is trademark. So trademark can be in many forms. So moving on to the next slide, where we will see what includes in a trademark. So a trademark is typically a name, a word, a phrase, a logo, a symbol. It can be a design, image, sound, or combination of all these elements. So by the word name, it means name over the kind of name over the right over the name. For example, the Facebook here, which you can see in this slide, the Facebook, it is the name. So such type of name can be protected under the trademark, or we can say the word or the logo, symbols. All these type of the logos can be protected under the trademark. The phrase, like you can see in the screen, I'm loving it. So that is the phrase which also can be protected. There are various marks which will come under the trademark law. The first is the color mark. The color mark, we all know the color of kind of the Dairy Milk chocolates, the color of your Facebook, the color of Google, the color of Microsoft, the color of McDonald's, the color of Domino's, the color of Paytm. So all these are protected under the trademark law. So it is, when we speak about trademark, we might think of that it is only the logo that is protected, but not only the logo, but the colors are also protected by the particular companies, by the particular brands. So here the Facebook color is blue, the color of the McDonald's is the red and yellow. The name is protected as the KFC. The name KFC is protected. The name Facebook is protected. So along with the color, the shape is also protected. Not only the symbol, design, images, the shape is also protected, like you can see in the screen. We all must have had a bite of Kit Kat chocolate. So this Kit Kat chocolate shape, these lines that are drawn, so that is trademark. So no other chocolates can use such type of lines in between their chocolates. So they have trademarked that thing, and they have protected themselves from the other competitors who are in the market. So if someone uses such type of lines or such type of stripes in the chocolate category, then it will lead to an infringement. So the next is the motion mark. The motion mark is that you can see it in the screen, the mobile phone, the Nokia mobile phone, which we had in the 90s. So in the starting of the Nokia phone, what happens was that there was a motion of two hands shaking. So that was the motion trademark. So nowadays, the Windows have that motion trademark. The Windows, in the starting of the Windows, we can see that motion mark. So all these motion marks are also protected under the trademark law. Next come the certification marks. The certification marks like the FASI, the ISO, or the hallmarks, all those comes under the certification mark under which the products are protected, which also comes under the trademark law. So next is the pattern marks. So here the pattern marks, you can see the pattern of Adidas. So there are 3 stripes of Adidas. Yeah. So this also represents the pattern mark. So Adidas have trademarked those patterns. However, how much the patterns are valid is uncertain, as there has been a case of Adidas with another company where the other company has questioned the trademark of Adidas, saying that it do not hold any creativity, like 3 stripes cannot be any creativity. So it is in question of the trademark brand. So there was another case, kind of the Starbucks coffee, which we all are aware of. So the Starbucks coffee versus Starbucks coffee. So it looks very similar, right? The Starbucks and Starbucks. It is a very funny yet very interesting case. So this Indian infringer, the Starbucks coffee is an Indian infringer who had the idea of copying the Starbucks by replacing the word star and putting it Sardar. So, and the case was filed in the court by the Starbucks, saying that it was kind of similar, which might confuse the consumers. So this type of similar things do confuse the consumer, as people thought that they are the same company, or they are the branch of the same company, and people were consuming the Starbucks coffee thinking that it is Starbucks. So it is creating a confusion in the minds of the people. So Starbucks has filed a case. So court has advised the Starbucks coffee to change their name to Sardar G Bucks and use it as their trademark, because Star and Sardar looks very similar. So if they use a word G in between, so it will help to differentiate their trademark in the same category. So this was the case of the Starbucks and Starbucks. So another case is the Coca-Cola versus the Bisleri. So upon the brand Mazda, so Bisleri had the Mazda, and they have assigned the Mazda trademark to Coca-Cola, but later on they had cunningly they have filed an application for trademark in Turkey, and they were using their own thing which they have already assigned to Coca-Cola. So now Coca-Cola has filed a case in the court stating that if they have assigned their work fully, if Bisleri have assigned their Mazda fully, then they cannot again file for trademark in some other country, since they have given already fully assigned trademark to Coca-Cola. Now the owner of the Mazda should be Coca-Cola and not Bisleri, and Bisleri cannot use their trademark by filing it in some other country. So these are the cases relating to the copyright, relating to the trademark law, which shows that the protecting trademark is very important. Otherwise, it kind of create confusion among the consumers. At the same time, it kind of makes laws for the people who are creating their own trademark and not protecting it. It can make a heavy loss to the one, because there are many infringers in the market who would definitely take chance to steal. So we need to keep in mind how to protect a trademark and what is the importance of protecting a trademark. So before moving on, I would also like to mention that we all know who is SRK, that is Shah Rukh Khan, okay, or who is SRT. So SRT is Sachin Tendulkar. So SRK and SRT, or the Akshay Kumar. So all these three people has some similarity. So if we see what are the similarities between SRK, SRT, or the Akshay Kumar, so we can find the similarity between Akshay Kumar and definitely Shah Rukh Khan. That is, both are the Bollywood actors. But what is the similarity with Sachin Tendulkar, who is the former cricketer? So the thing is, they have trademarked their name. So SRT, that is the Sachin Tendulkar, has trademarked his name, that is SRT. And we come to know this from the movie Ferrari Ki Savari. There was a movie called Ferrari Ki Savari, in which permission was taken from Sachin Tendulkar to use his name, to use his trademark in that movie. So he has trademarked his name. So trademark can also be given to the names, but for that it should, you need to give the valid reason why you are doing so, or what are the valid reasons under which protection can be given, that we need to look into. And SRK, in the similar way, SRK have trademarked his letter, the three letters, that is the SRK, so that no one can use these letters without his permission. When it was asked why he was kind of why he trademarked his name, so it came to the people that his name was being used as a acting academy. People were using his name for acting academy, which was fake. Kind of in his name, people were earning profits. So all these type of circumstances led him to trademark his name, and from then people were not able to use his name, and if they used it would lead to infringement, and there would be a case relating to that. So he protected his name in that way. And Akshay Kumar, well, Akshay Kumar have not trademarked his name Akshay Kumar, but he has trademarked his name Khilari Kumar. So the Khilari Kumar is his trademark name. So he has trademarked Khilari Kumar. Now no one will be able to use it. Even if they use it, there will be protection or infringement of the trademark law. So let us move on. Why is the trademark necessary? The registration of trademark is not compulsory. Well, registration of copyright or registration of patent or registration of trademark, all these are not forced upon people. But if there is trademark registration, it will benefit the people when there is some infringement. Otherwise, it will be very difficult for the owner to prove that that work is his own, that trademark is his own. So while going to the court, a person need to give proof that it is his trademark. It was he who was the right owner of that product, the right owner of that particular symbol, who has created that particular logo. So in order to prove that, the person needs to get his logo or to get his brand registered. Unregistered user has to search remedies in common law. So unregistered users do not get protection under the Indian trademark law. So here you might have seen these marks in the maybe in the packet of chips or the things that you use. It is the service mark. SM is the service mark. Service mark can be of the services like the airline services, the transport services, the trademark, and the registered. So they both have a slight difference between them. The TM is used when the thing has been filed but not yet registered. It may not be registered, but the R is used when the thing has already been registered or the product has already been registered. So since trademark takes time for about 2 to 3 years of time to get the trademark. So in that process, if a person files for the trademark, then he can use the term TM. And after it gets registered, it will come as R. So this is the difference between trademark, R, and SM. So let us move on to what is design. So design, we all must be aware of the Sabyasachi lehengas, the Sabyasachi saris, especially the women's. So all those are the design, and Sabyasachi had got various protections for his work, protection under the patent law, protection under the copyright law. So he has protected many of his work and was also awarded for protecting so many works of his. So he is the designer whose work got protected. He is actually the first person. And also Manish Malhotra, his works are also protected. So these are the famous designers of India. Well, what is design? So design is a feature of shape, configuration, patterns, ornaments, composition of color or line or combination thereof applied to an article. So to be a design, it is it should be applied to an article. So it is not only that design should be kept in a particular place, because after a drawing, after a work of art, that person needs to apply it in a particular article, in a particular product or a thing, whether it can be 2D or 3D, and by any industrial process, and it should appeal to or solely judge by the eye. So here design is only kind of which appeals the eye. It should be only the outer look, which will get protection under the Design Act 2000, the Indian Design Act 2000. But we cannot protect the design which are kind of functional. Like nowadays, we can see there may be a product which designer kind of attached to the functional use. So if that design have some functional use, then that will not come under the ambit of Design Act. So design, under the Design Act, only those designs will come which has no functional aspect, but only the aesthetic, only the outer look which we can see by our eyes. So we know that the industry is today, the colors, the shades of colors, which attract various businesses, and the designs, various designs, the kind of catch our eye. So it is very important to protect the designs as well. So there are few conditions which needs to be fulfilled before getting a design protection. That is, the design needs to be the new and the original work of the owner. So it cannot be that we can copy someone else's design and we name it in our own and get it protected. So we cannot do so. So, and it should not be disclosed to the public before it gets protected. It should not be kind of which is against public order or morality or something which is obscene, or it should not be it should not comprise of any scandalous material. So to be a design, all these things should be fulfilled. It should be new, original, it should not be published. So then only it will get protection under the Design Act. Well, there is punishments for the Design Act also if it is violated. So if anyone violates some other person's design, then they will be liable for compensation or the fines, which will be kind of 25,000 to the registered proprietor. That means the owner of the design may get 25,000 as a fine, which can extend to 50,000. But it shall not extend to 50,000 as stated in this section. So if anyone violates, that will be called the pirated design. So if there is any fraudulent imitation of a particular design without the consent of the design holder, then that will be called pirated design. So such type of design, for such type of design, there is infringement and punishment under the Design Act. And let us look into a case. The Dabur India Limited versus the Rajesh Kumar and others, 2008. This suit was filed alleging infringement of design in replacement of a bottle which was being used by the plaintiff for packing hair oil. Now, the court found that the bottle to be a common bottle used by the several other companies. So this shape of the Dabur bottle, such kind of bottles were being used by the Rajesh Kumar, and Dabur had filed a case against Rajesh Kumar saying that they have stolen the design of that bottle. But the court held that the bottles are kind of very common. The shape is very common, and no peculiar features of the bottle registered as a design. So that was peculiar feature was not registered under the Design Act. So it could not be protected by the Dabur. So there are various other cases of the infringement, like the parachute oil also have the cases of infringement. So how the court will decide if a particular shape or if a particular design is kind of similar? So for that, there is a test of infringement, like the court will place the product side by side. The court will not place the product side by side, but rather examine from the point of view of a customer with average knowledge or imperfect recollection. So this means that just from the average customer's knowledge, the things will be judged. Like if we look at a thing and if we get ourselves confused with the design of another, so that itself gives us an idea that that thing is a copied version, or that thing might confuse the consumer. So in that way, the court manages to see if a particular thing is infringement or not. So moving on to our next topic, that is the geographical indication in India. So before moving on to the definition of geographical indication, let me show you this. The geographical indication in India, you must have all heard of this basmati rice, the Darjeeling tea, the Kanjipuram silk, the Nagpur orange, the Agra petha, the Goa feni, the Navara rice. So all these are the geographical indication which got the geographical tag. Now, what is geographical indication? Now, geographical, when goods come from a particular place and the quality of goods are attributed to that particular place of origin, so that holds the criteria of getting a GI tag, which we call GI tag, geographical indication tag. So if that particular agricultural product, manufactured product, or that natural product, if all these categories product have a particular unique characteristics which gives you the idea of its origin, then those type of products get the GI tag and get protection under law, the Geographical Indication Act, under the Geographical Indication Act. For example, let us take the example of Tirupati Laddu. So you all might have tasted the Tirupati Laddu. So Tirupati Laddu has a very unique taste, and the process of making it also is very unique. So today I cannot make laddus at home and sell it as Tirupati Laddu. So what needs to be done is we need to give the name of Tirupati Laddu whenever we are using it or selling it. So that gives the right to that particular place, to that particular place of origin to that particular product. It gives a reputation to that particular product, and it also helps in economy of the country by helping the particular region people to sell their products globally. They can sell their products like the Darjeeling tea. Now the Darjeeling tea is kind of well known globally. So why it has happened? Because Darjeeling tea has got the GI tag, and they are able uh, to show it to the whole world as a Darjeeling tea, not any other tea. Now I cannot sell the tea of Assam, saying it to be the Darjeeling tea, and that will lead to be an infringement. So there are particular or unique things which have got GI tag over India. There are various list of things, but it is less in number compared to other countries. So an awareness in this sector is also very necessary, because the list is very less. There should be more awareness, as there are many more things in India which could come under that list. So the things that have got protection till now are the kind of Kashmir Pashmina shawl, and the Nagpur orange, the Kangra paintings, or we can say the Madhubani paintings of Bihar. Recently, there was a controversy of Rasgulla between the West Bengal and Orissa. The 2018, the Chow Mask of West Bengal got the GI tag. And there are various, the Assam, from Assam, the Muga silk got the GI tag, or the brass metal of Assam got the GI tag, and various lychee, the Nagaland Naga chili got the GI protection. So also the Chanderi silk of Madhya Pradesh, which you might know. So in 2010, the Chanderi silk sari was used in the Commonwealth Games in Delhi, Commonwealth Games, and there was demand of that sari. It is kind of lakhs of saris were being made, and the kind of weavers were in demand at that time, and they have earned various profits by selling those saris. So it helps in economic growth also. So if we protect the GI of our own region, then it will ultimately, along with the development of the place or the region, it will also lead to development of the whole country. Therefore, the protection of GI is also very essential. So for all these IPRs, be it the copyright, be it the patent, the geographical indication, the trademark, or the trade secrets, which I did not mention. The trade secret is kind of confidential information. The products, confidential information in the sense, the masala of Maggi, which we do not know, the ingredients in Coca-Cola, which we do not know. All those are the trade secrets. So there is protection for all these trade secrets also under the IPR, because there has been, like Maggi, we have many other products like UP, YY, there are many other products, but no one is similar to the particular Maggi which we eat every day. So that is because of trade secret, which is kept as a secret by the owners of the Maggi. So all these things are protected under the geographical indication. So you might have a question like, now how to protect these products, or where to go to protect these products. So you can sit at home, and today you can go and search for the IP India website. So IP India will give you a view of what is copyright, trademark, GI, and it will also give you the place for filing an application. How you will file an application, you will find each and every detail in the IP website. So IP India is the website, and there are various head offices for patent, trademark, it is in Kolkata, the nearest, for Northeast, it is Kolkata, it is Delhi, Chennai. So there are many offices of IPR which are there, where we can go and file our own the patent, GI, or copyright personally, or we can do it online. And there is fee for all these types of product. The fee kind of varies from product to product or from categories to categories. It can vary. But for geographical indication, it is a community right. It is not an exclusive right. Since geographical indication is a community right, so any person or organization can file. Individual can also file in the name of that particular reason, or for all the other categories. For all the other categories, the individual as a whole, or for the patent true inventors, or their representative, or their legal heirs. Legal heirs means if the person dies, then his legal heirs can file a case in his name. So they can go to the patent office, trademark office, or can search it in IP India website, where there are various offices and where there are various procedures to file a IPR rights.
So, ma'am, sorry to intervene. There are some questions which have been popped up. If you permit, may I ask the questions, please?
Yeah, sure.
Yes, ma'am. One question from Mr. Sandeep is, will Tirupati Laddu comes under GI tag?
Yes, ma'am. Tirupati Laddu comes under the GI.
Yeah, that is what we saw on the screen as well.
Yeah.
But I wanted to ask a question.
Is there any other questions?
Yes, ma'am. Ms. Kanchan, she is asking, if any faculty prepare e-content and have copyright, can the institution use that content? Will it violate copyright?
May I
Repeat the
ask
question.
for one? Yeah. Can you please repeat?
If there is any faculty who prepares an e-content and have a copyright, can the institution use that content? And will it violate copyright in case if any faculty is making any video, e-content, she is developing any e-content, and she is already holding the copyright for that content. She wants to ask if the institution to which she belongs to, they can use that e-content on their name, or is it something related to violating the copyright?
Okay. So if you are preparing the e-content, so copyright generates automatically. So that means that you are the copyright owner of that particular e-content. And if the institution is using your e-content for the educational purpose only in the university, then that will not lead to copyright infringement. So if the university is as a whole showing your e-content to the students or for any educational purpose, for any seminars, so that will not lead to copyright infringement. But if someone is taking a video in that seminar or in that program, if someone is taking a video and it is uploading it in YouTube, or it is uploaded any other social media platform where he can gain profits, so that can lead to copyright infringement. But we cannot directly say that if the institution uses your e-content, that may not lead to copyright infringement. We need to see the purpose before giving it a blame of infringement. We need to look into the purpose for which it is used. Like if I created e-content for you all, it will not lead to copyright infringement, because the purpose is to the educational purpose or the research purpose will not come under the purview of copyright infringement.
All right. So will it be?
I hope, it clears you.
Yes, ma'am. I think she has written that. Okay, I got my answer. Thank you so much. And further extending this question, I would like to ask if this, whatever you were saying, that the institution can use that video or e-content for educational purposes, is it till that faculty is associated with that institute, or after, if she leaves that institute, the institution can use that content as well?
No, it is not necessary that the faculty needs to be related somehow with that institution. It is not at all necessary. Even if we don't know who is the original maker of that personal e-content, then also we can use it. Like in today's world, if we download a slide and if we use it to show it to the people or to show it to the students, then also it will not be an infringement. Since the purpose is very clear, for the educational purpose, it is very clear that that will not lead to any kind of infringement, even if we don't take the permission of the copyright owner.
All right. And in case if the faculty herself would like to, use it for some commercial purposes, for instance, that I have a YouTube channel, maybe I am uploading those videos over there. So will it be fine that without taking the permission of the institute, I am uploading the content on my YouTube channel, or will it be necessary to seek their permission also?
When the things are being used for commercial purpose, then the consent of the owner is very much essential. So when you are benefiting something, then you have to take the consent of the owner. Only after taking the consent, you can upload your videos.
All right, ma'am. All right.
Yeah.
Thank you.
Are there any other questions?
Yes, ma'am. Another question. Can I copyright multiple things in one application?
Yes, it is. You can copy. You can register your things for multiple things. Like for trademark, there is categories. For the trademark, there is category of goods where you need to do it separately. But in copyright, you can go for multiple things. Like copyright generates automatically. You do not need to go and register at the very first hand. But if you want more protection, then only you need to go for copyright protection. So if you want to do it for poem or for paintings at the same time, you have to give it kind of under the same application. You can give it, but you need to give the specification separately. Specification in the sense you need to give a copy of the paintings, or you need to give a copy of your poem. So that will be separate, but the application can be the same.
All right, ma'am. Thank you. No other question, ma'am. We can proceed. All right.
Okay. So I guess the time is already ending. Yeah, I'm restricted by time. So I hope
there is
my lecture.
There is one more question extending the same question which Ms. Manju posed previously. She wanted to ask, duration for the same will be?
Duration of?
Of the copyright?
The duration of the copyright will be the lifetime plus 60 years. But for music, it might differ. Kind of for music, since music is kind of under different categories, like the owner of a music copyright is generally the composer, but the lyricists also get the copyright under the literary works. So if it is literary works, so it will be lifetime plus 60. As I have already mentioned about the Mahatma Gandhi's book, which got into the public domain after 60 years, it is lifetime plus 60. So after the death of the person, it will extend to 60 years, and then it will go to public domain.
All right.
Yeah.
Thank you, ma'am. So, ma'am, you would like to continue, right?
So I hope this session has benefited you. I just tried to give or try to make you understand what is IPR with the least knowledge that I have. So I have tried my best to give you the idea of what is IPR. So I hope it is beneficial to you in some way. So thank you so much. And thank you, ma'am, for giving me this opportunity for giving the beautiful lecture. And I hope we do meet personally in our near future. So please do visit our university as well. So thank you so much. Thank you once again.
And I think, ma'am, you very comprehensively and in very easier, language made us aware, made us know about everything about the IPR, the basics and the copyright, all these things. And I think the audience, they are also clear about whatever content has been shared by ma'am. In case if any of the participant has any question, they can pose it.
Yeah, definitely.
In the chat box, in question answer box. The platform is open for questioning. I repeat, if any of the participants have any question, they can write the question in the chat box or the question answer box. And moreover, I would also request the participants to please fill the feedback form on a mandatory basis. Feedback link for this session will be shared after this session. All right, I don't think so, ma'am. There are some questions. You explained it very well, ma'am.
Thank you so much. Thank you so much.
With you. Professor Jaiswal, would you like to say something? You are muted, sir. Sir, you are muted. You need to unmute yourself.
जी थैंक यू मैडम। मैं अभी जस्ट जो स्पीकर थे उनका लेक्चर सुन रहा था बड़े ध्यान से। काफी डिटेल्ड में उन्होंने आईपीआर के बारे में बताया और बड़ी बारीकियों को बताया और बाकायदे उनकी स्लाइड्स भी मैं देख रहा था, बड़ी अट्रैक्टिव स्लाइड्स थी। मैडम ने काफी रिसर्च किया होगा इस पे। तो आई थिंक दिस विल बी वेरी फ्रूटफुल फॉर ऑल द पार्टिसिपेंट्स, ऑडियंस एंड आल्सो इस पैनलिस्ट आल्सो, क्योंकि आपने हम सभी के जनरल नॉलेज को इंक्रीज किया, बढ़ाया आईपीआर के बारे में। तो थैंक यू वेरी मच फॉर इनलाइटनिंग अस। थैंक यू।
Thank you, sir. Thank you, sir. It is my pleasure.
Thank you, sir. And at the end, all right, there is some comment by Dr. Neetu Chawla. I think ma'am has covered all our doubts. Thanks a lot. So a speaker is thanking you for the presentation that you have made. And they are saying that they have a clear understanding of the thing.
Thank you all for having this patience for 2 hours. So thank you so much.
All right, now I would like Dr. P.C. Jena, School Coordinator, School of Education, K.R. Mangalam University, to formally present a vote of thanks to Dr. Manjeera.
Thank you, madam. Thank you, madam. Actually, from the very beginning of the faculty development program till end, I was there, and I personally learned so many things. And this faculty development program, it is not an opportunity. It will create hope for student of humanities and a student of education, how to prepare a patent, how to upload it, and how to make it successfully. And first of all, I am very thankful to Manjira Madam ji, today's resource persons, and she has very extensively explained everything in a right manner. And moreover, sometimes there was a question. कभी-कभी हमारे पास ऐसे भी क्वेश्चन आ सकता है, मैं एजुकेशन स्टूडेंट हूँ, क्या मैं पैटेंट कर सकता हूँ? इट वाज ए मैटर ऑफ कंट्रोवर्सी. कभी-कभी बोलते हैं एजुकेशन में तो पैटेंट हो नहीं सकता है, बट ये जो प्लेटफॉर्म से हमने सीख रहे हैं, क्योंकि नहीं, एन एजुकेशन स्टूडेंट कैन पुट ए पैटेंट तैयार कर सकते हैं. सो थैंक यू अगेन मंजीरा मैडम जी for enlightening us, and you have very thoroughly explained in a very better manner. Then I am also thankful to all the participants from various states, those who are associated with us, and madam has already explained very beautifully the response or answered the questions which has been raised by different participants. I am also thankful to our leadership teams of KR Mangalam University and our Dean Madam Professor Tanya Gupta ji, and I am also very thankful to Professor Vijay Jasal ji, and she has already, despite her his busy schedule, ये हमारा पास में देखा है from the very beginning, ये भी हमारा साथ जुड़े रहे हैं, and many thanks sir, आपने हमारा लिए टाइम स्पेयर किया है. And I am also thankful to all the team members of organizing this faculty development program of KR Mangalam University and other members of CS University, also Chaudhary Charan Singh University. And I hope such type of faculty development program is very essential to make or to prove the education student a right person. And thank you madam, and I hope and every session will be bring a fruitful session for us. So again I am thankful to all the participants and all the team members and the media persons, those who are associated with us. Thank you. Namaskar.
Thank you so much, sir. The feedback link is there in the chat box, and the link will also be shared on the WhatsApp group. Kindly fill that feedback form by today itself after 11:59 p.m. The link will close. Thank you so much, Manjira ma'am. Thank you, Professor Jaiswal.
Thank you.
That has been a nice interacting with you and for such a beautiful session.
Thank you, ma'am. Thank you so much.
Thank you, ma'am.
Thank you, madam. Thank you.